Hello everyone, welcome to CashcroftTV. My name is Kalen Ashcroft. Thanks for watching this video on Guide to Legal History and Historians, where we will be covering all of the authors and chapters of the Oxford Handbook of Legal History, edited by Marcus D. Dubber and Christopher Tomlins. Today we will be covering the chapters by Elizabeth Dale and Paul D. Halliday, those being Spelunking, or Some Meditations on the New Presentism by Elizabeth Dale, and Legal History Taking the Long View by Paul D. Halliday. So, as with all these videos, it's going to be a 2x2 comparison in the style of Plutarch's Lives, so there will be a comparison at the end, and please note none of these videos must be watched in order, and I in fact prefer if you do not. So I've kind of got a new system here. I've got my biographies in my journal, and then I've got my typewritten notes for the chapters, so hopefully I'll be able to navigate through this, but it's my second time doing so in this style, so should be all good. So without further ado, we will begin with Elizabeth Dale's chapter and biography as well. So a little bit about Elizabeth Dale to begin. She's a professor at the University of Florida, both in the Department of History and in the Levin College of Law. She has a Juris Doctor from the Chicago-Kent College of Law, which she received in 1994, as well as a PhD in History, which she received from the University of Chicago in 1995. She also has a Bachelor of Arts from DePauw University, Greencastle, Indiana, in Ancient Greek, graduating in 1981. However, she transferred there, it seems, from Swarthmore College, where she studied from 1977 to 1979. She is also served some time as a lawyer and as an associate in the law offices of Kenneth N. Flaxman in Chicago, working on civil rights, employment law, criminal appeals from 1985 to 1991, so some significant work as well, practicing in addition to her legal career. She's been a visiting professor at the John Marshall School of Law, a visiting instructor at DePaul University, an assistant professor at Clemson University, an assistant professor at the University of Florida, a Fulbright scholar, a researcher at the Shandong University in China, as well as a visiting professor at the University of Chicago, and an associate professor there as well, from the time between 2002 to 2012, and in the University of Florida she became a full-time professor as well. She's also was an affiliate professor at Levin College of Law from 2001 to 2012, before she became an official professor there too. And since she's been a professor of history since 2012 and a professor at the Levin College of Law since 2013. So coming up to her 10 years on one and coming up to 10 years on the other. She has produced 6 books, for, the most recent being Fight for Rights, A Legal History of the Chicago Race Riots of 1919, published by the Liberty Press at the University of Florida in 2022. Next book, The Robert Nixon Case and Police Torture in Chicago from 1871 to 1872, published by the Cornell University Press in 2016. Criminal Justice in the United States. This is our next book, between 1789 to 1939, published by the Cambridge University Press. New Histories of American Law series, published in 2011. Next book, The Chicago Trunk Murder, Law and Justice at the Turn of the Century, published by Cornell University Press in 2011, so 2 books published in 2011. Next book, The Rule of Justice, The People of Chicago versus Zephyr Davis, history, published by the Ohio State University Press, Criminal Law and Criminal Justice series in 2001. Next book, Debating and Creating Authority, The Failure of a Constitutional Ideal, published by Massachusetts Bay, 1629 to 1649, published by Routledge Press in 2017, and by Ashgate Publishing more previously in 2001, the first edition. Her aim in terms of her research is to bridge the divide between the history of law and constitutional history by looking at when and how people have influenced systems of formal law. In addition, she's also the coordinator for the Juris Doctor, Master of Arts, and PhD program at the University of Florida, the coordinated programs, and a founding member of the Digital Humanities Graduate Certificate Program, and a member of the University of Florida Mellon Intersections Working Group on Mass Incarceration. So, very significant both professional career as a lawyer and as an academic at many institutions, mostly very much in Chicago and also in Florida as well, and many other regions as well. So, without further ado, we'll discuss her more in terms of her comparison with Paul D. Halliday, but with respect to her chapter that she wrote in the Oxford Handbook of Legal History. It is titled Spelunking, or Some Meditations on the New Presentism by Elizabeth Dale. So this is chapter 17, but please do not watch these in order, and this will be compared with chapter 18 of Paul D. Halliday. So, in terms of the introduction, she opens with this quote: "In 2017, the apparent dawn of a post-truth, alt-facts era, history has become the rage." So she cites 2017 as a shift, likely due to the change in leadership at the time in terms of a greater interest in history. Articles that discuss the age of Trump, according to her, has made undergraduates pursue history courses while pundits debate the meaning of the administration's embrace of Andrew Jackson. Deneen L. Brown says in his article, Trump called Andrew Jackson a swashbuckler. The Cherokees called him Indian killer. Retropolis at the Washington Post says the enthusiasm is understandable, is somewhat unexpected corollary. There's also been an increased interest in the past to understand the present, and has marked what Dale calls new presentism. That's the primary topic of this chapter as well. She is uncomfortable in what seems to be a world suddenly gone mad and irrational. However, she rejoices at the possibility that undergraduates might want to study history and its corollary, that some graduate students in history might therefore graduates in history departments might find jobs as well. So there's been a kind of an increase in popularity in courses, but also through effect that will lead to more jobs for the historical scholar. She does not oppose New Presentism. She has noted in It Makes Nothing Happen, Reasons for Studying History of Law in 2009, published by the Journal of Law, Culture and Humanities. And furthermore, she became a historian in order to use history to speak to and about the present. So this is what she's tried to do with her career too. So just because this is a growing trend doesn't mean it's a bad trend, and in fact she thinks it's a good trend. However, we'll see some people do not think so, but she will endeavor to critique this notion. She has given impromptu lessons on the history of impeachment and the Electoral College, and she has tossed out her original lesson plan on day one to teach about the O.J. Simpson verdict, and spent several weeks at the end of the fall semester in 2000 helping history students and colleagues understand the historical background in the issues in Bush v. Gore. She has been on panels about the Trayvon Martin tragedy, and wrote a history of the lost stories of police torture in Chicago in the years before John Burge and his crew tortured suspects in the south side of Chicago. Her book, Robert Nixon and Police Torture in Chicago, 1871 to 1971, published by the Northern Illinois Press in 2016, further elucidates her value in presentism. And she's also written books that used history to make questions of law accessible to popular audiences. So she's kind of really capitalized on this growing trend towards new presentism, and has perhaps always manifested it throughout her career, even before 2017. In her book Criminal Justice in the United States, between 1789 to 1939, published by the Cambridge University Press in 2011, and the Chicago Trunk Murder, Law and Justice at the Turn of the Century, published by the Northern Illinois University Press in 2011. also further elucidate this. Yet she thinks we need an approach to new presentism with care. Her concern is not the practice of presentism itself, rather she wonders about what it says about how we view ourselves and the role in the world in which we find ourselves today. So that is the introduction. This will all probably come together much more clearly very soon. So her first section is called Presentism. So what is presentism? So for many years, she says, the rule was simple. Good historians rejected present-minded history. That was the first lesson of undergraduate methods according to her courses, as well as a well-worn principle of graduate history seminars. The claim prompts obvious questions. What is the thing historians must so carefully avoid? The works deploring the practice call it by a number of names: the Whig interpretation history, law office history, or present-minded history, progressive history, and applied history. So these are all different names that sort of encompass what new presentism is. As the large variety of epithets suggest, presentism embraces a broad range of bad historical practices. So it's kind of a term, a catch-all for anything that people don't like relating specifically to the present, but also there's this political notion behind it as well. As a practical matter, they share a common emphasis, however, or a common premise, is that we use the past to help explain the present. Our understanding of either, or sometimes both, will be distorted. So there's an issue that one might note if you're using the past to analyze the present, that you're either focusing one perhaps is wrong and you're trying to fit it in a perhaps unfitting mold. There are many canonical works of early history were written with this eye, so it's not necessarily a new thing, although it might be growing in popularity. For example, the History of the Peloponnesian War, which is one of my favorite history books of all time. I just polished that book off. I absolutely loved it. As well as William Bradford's Of Plymouth Plantation and Edward Gibbon, The History and Decline of the Fall of the Roman Empire, written between 1734 to 1794. These were all canonical works, but they also had an eye for presentism. So in that they were written at a time where they wanted to have implications on the present in which they were writing. There's still a full-throated opposition, however, to presentism has dominated historical study for nearly a century, such as Alexander Butterfield attacked the Whig interpretation of history in 1931, stating historians describe the past as inexorably leading to a liberal constitutional present or future. So there was kind of, some say it has a liberal agenda perhaps behind it. David Hackett Fisher deplored historians in Historian's Fallacy in 1970, whose sense of American history is a steady progress of pragmatic liberalism from Jefferson to Jackson to Roosevelt, to Franklin Roosevelt. Lynn Hunt says in the crudest form encouraged a kind of moral complacency and self-congratulation. So there's obviously these critiques that first that perhaps it has a liberal agenda, but also that it's sort of self-fulfilling or self-congratulatory. There are criticized specific political perspectives that often drove the arc of history. For example, Alfred Kelly, in his famous article, Clio and the Court, condemned what he calls the law office history, another synonym for new presentism, where it is written to serve the interests of a libertarian idealism. Karen Tanney and Alfred Brophy in their debate in 2012, feared there was too much emphasis on historical study that had current application might encourage neoliberal efforts to reduce all scholarship to work that had a practical application. So maybe if you get rid of the stuff that doesn't have practical application, you might be missing a large parts of the puzzle. As well, the history departments find themselves compelled to offer courses on subjects that the students want, but the concern, as they saw it, there was no point to view the advanced stuff as well. Butterfield also argued that the answer to presentism was not to replace the faults of the Whig bias with a Tory focus, so it's not necessarily the issue that it was liberal, as these problems transcend presentism. history departments find themselves compelled to offer courses on which students want. So it's perhaps this liberal bias is just a reflection of what the students want, and therefore that's why that's what they need to do to get funding, this form of presentism. Historians find it often difficult to publish work that presses have deemed out of fashion. Even well-intentioned scholars may accidentally manipulate evidence or interpretation to support a thesis, perhaps political or for some other reason. The solution to these problems, aside from continuing to produce history that is unfashionable, is, as Butterfield admitted, for each generation to write and rewrite history. So just by continually doing it, it will keep getting updated, but you will also get the full variants as well, hopefully. And to endlessly revise our understanding of the complicated nature of the past. This need not mean shutting out engagement with the past that is tied to the contemporary concern. For example, Lynn Hunt, at the end of her essay on presentism, titled Against Presentism in 2002, called just for that, calling for historical exploration that kept the past and present in creative tension by using the insights of the present to expand and reconfigure the inquiries up into the past. So that is the first section on what is New Presentism. Hopefully you get a sort of feel of what it is and what she is trying to elucidate. The next section is called The Rise of New Presentism. So New Presentism might differ from Presentism as well. So Lynn Hunt's remarks on presentism in 2002 in her Against Presentism essay marked a renewed interest in approaches that tied the study of history to the present. There were several reasons why this interest arose at the turn of the 21st century, after years in which the tenure-track jobs became harder to find. So as tenure tracks became harder to find, they needed to make a change, that is to New Presentism. And many members of the profession concluded that if history as a discipline was to be preserved and the training of future generations of historians to be continued, then histories and departments had to find ways to show that their historical inquiry was useful to the world outside the academy. So therefore, New Presentism had to have a sort of purpose in the present, otherwise they couldn't get funding or find jobs. And the response was this was in response to both declining enrollments in history courses and diminishing employment opportunities for students. There's also been further support for presentism came from many scholars who felt that arguments against usable history all too often were marshaled against efforts to make issues of sexuality, disability, or the lives of women or people of color valid subjects of historical inquiry. So often they were molded to fit these agendas, or if they were not considered relevant. Hunt conceded to the point in her piece, pointedly noting women's history, African American history, Latino history, gay and lesbian history, and the like have all made fundamentally important contributions of our understanding of history. Unfortunately, she noted, opposition to these types of history was often framed in terms of presentism. So there was also this counterforce that presentism would perhaps even hold these areas back, precisely because attacking the method of study rather than the subject provided a neutral-seeming cover for efforts to erase some people from historical study. So by using presentism, they could say, oh, this is not relevant, perhaps, therefore they could attack it without attacking it directly, supposedly. And in response, some historians at the turn of the century embraced presentism because it allowed them to explore history of historiography that made those erasures possible. So perhaps it was used as a tool to suppress some of these less popular topics. Others came to believe that those fortunate enough to be able to pursue careers in scholarship had a responsibility to use the positions for a greater good. So there's kind of an obligation to use history in this New Presentism manner. Ibram Kendi, for example, argued that the training and relative leisure to think, explore, and reflect given to those who are paid to do scholarly research carried with it an obligation to put those privileges to good use by exposing the lies, erasures, and distortions of the path by government and scholars. And therefore, it made presentism a necessity, not just an option. For example, in the article, Are You an Intellectual? He presented at the in the graduate commencement address at the University of Florida in 2016. So even at the graduating event, commencement address, or starting address, it's kind of putting this new presentism ideology upon the students of perhaps all fields of study. In the first years of the 21st century, these discussions about presentism remained within the discipline and set out in scholarly journals, conferences, and the occasional public lecture. However, the presidential election in 2016, as she noted, quickly pulled these conversations out into the real world. For example, on April 3rd, 2017, the Washington Post launched what's called Metropolis, a blog aimed at connecting present-day news with its rich history. So a blog dedicated to presentism in response to the 2017 election. Although written for the Post by the Post reporting staff, not historical scholars specifically, the paper promised the blog would be historically grounded with materials drawn from the paper's archives in collaboration with Washington's many libraries, librarians, museum curators, and historians. It inspired by the notion that much of the news we cover today has echoes in the past, and the histories published on the blog rarely offered much depth, however. A few months later, Moshe Temkin took to the pages of the New York Times to argue that historians should provide a critical and comfortable account of how we arrived at our seemingly incomprehensible current moment. So this new presentism debate was very much revived in 2017, probably likely due to the polarity. In other words, history had to be interpreted by historians, not simply pulled out of an archive and dumped onto the web or into a news account. So they had to be interpreted too, which is a key aspect of new presentism. It did not refer to the Metropolis specifically, this latter work. However, the argument was that history had become too important to leave to amateurs, whether they were presidential advisors who prided themselves on reading Thucydides, one of my favorite books, or newspaper reporters who drew on newspapers' morgues to explain policy. So there's also a sort of elitism, perhaps, associated with this. At roughly the same time, Keisha Bain and Ibrahim Kendi, whose commitments to publicly engaged history led them to create the history blog, Black Perspectives, called on scholars to step out of the shadows of their libraries in order to fight the onslaught of fake news and alternative facts. Thus, New Presentism was born. So we can kind of cite the inception of New Presentism versus Presentism at 2017, given the polarity of that election. Your next section, from theory to practice. So now that we've just figured out what presentism is, New Presentism are, we move to from theory to practice. So what does New Presentism mean for legal historians? Contra Alfred Kelly, the proponents of New Presentism do not argue, as did Justice Black in his appendix to Adamson v. California, that history can or should prove that those who wrote the 14th Amendment intended to incorporate the entire Bill of Rights. So, nor do they believe that legal historians will be able to settle once and for all the questions of the scope of the Second Amendment truly is. So there's no definite end to New Presentism, regardless of what Justice Scalia and Stevens tried to assert in Heller v. District of Columbia. So there's perhaps no end, which she advocates to keep analyzing history into the present. Rather, their notion that historians have a responsibility to the public means that historians have a duty to help explain the context in which the legal rules that are applied were adopted and help uncover the experiences of people on whom the laws have been enforced. So how should we do it then? To some extent, according to her, we need to continue to do what has always been done. Alfred Brophy, in his overview of applied legal history, which is also perhaps another synonym for New Presentism, argued that we need only look around to see the various ways in which historical legal scholarship has always spoken to the present, even as it struggled to add to our understanding of the past. So he notes that New Presentism has perhaps always been there, or there are evidences of ways in which one might do it throughout all time. There is an example of legal historians who have testified as experts in cases involving election laws and voting rights, or the example of scholars who waded into contemporary debates writing on topics like the Second Amendment, so this reanalysis of past history. That work did not provide a final answer on what gun laws should be, but over several decades of historians across the political spectrum, the debate has been complicated and deepened, however. Also, the example of legal historians who wrote the amicus brief that helped shape this ruling of the same-sex marriage, according to Michael Grossberg and Friends of the Court in 2010, as well as Sally Hayden's The Slave Patrols, too studied the way in which Virginia and South Carolina policed their slave populations until the Civil War might seem at first glance to have little to say to contemporary law or policy, yet participants in debates over policing inspired the Black Lives Matter movement have suggested they have made arguments informed by her study. So all of these past evidences of new presentism must be looked at in terms of how we might apply it in the future, and that is specifically reanalyzing it, and sort of all of these scholars just mentioned, they sort of dug up things that a lot of people had thought the doors were shut on, and then sort of reinterpreted it, and that is much of the goal of how to approach new presentism today. Keisha Bain and Ibrahim Kendi in How to Avoid a Post-Scholar America, published in the Chronicle of Higher Education in 2017, argue that must be made available and accessible to people outside the academy who might make it useful, so that's part of that obligation as well. It must be available to everyone, even if it may be better come from the experts, it should be available to all. Outside confined journals that are published behind paywalls and books that are priced for academic libraries. For example, this book, for example, is one of the most expensive textbooks I've ever owned, but however, I'm very proud to have it, but it's not necessarily accessible to everyone. However, I hope by sharing this, you can get a taste from it, and hopefully maybe save up and buy one yourself. Working with museums, national parks, or institutions to translate academic scholarship into publicly accessible exhibits or others. That's another way of doing it, through public areas, like museums are very reasonably priced compared. You could go to a museum almost 100 times as it would cost you to buy some textbooks. And as well, like national parks put up exhibitions and stuff available to the public, and also maybe more accessible to other people who aren't as necessarily trained in reading scholarly works. So one who doesn't read all day might be more responsive to some presentation as well. There's also digital archives like Georgetown University Working Group on Slavery, Memory, and Reconciliation, which is an archive created recording the history of the university's ownership of slaves, published in 2016, so a very transparent way of doing it, but also available completely to the public and prospective students and alumni as well. The legal history blog, Black Perspectives, the blog of the African American Intellectual Historical Society, is also another source that is available to the public. And they cannot control what readers do with their work as well, which is a benefit and cost, but overall a benefit. And good history does not drive out bad history by virtue of its intrinsic merit. So that's a little caveat that there will be some perhaps productions of less valuable work, and the good ones won't necessarily get rid of the bad ones, but just by covering everything, hopefully you'll get the best regardless, or a better picture. So moving to the last section of her chapter, it's called Into, Out of, or Round About the Cave. And I say she used the Oxford comma, which I appreciate in her title. New Presentism's idea, she says, that historians have an obligation to use their training to help society has an illustrious pedigree. She says, after all, it is the point of Plato's allegory of the cave in Book 7 of the Republic. So I'm using the allegory, Plato's allegory of the cave, as sort of an analogy here, or past historical evidence of the necessity of this. So those who were removed from their chains and brought out of the cave into the light of the world in Plato's Republic, which is an absolutely fantastic book, one of the first books on philosophy I read, but it took me a very long time to read compared to other things like The Prince. It took me like a couple of weeks to read, but the Plato's Republic was quite a slow read because it covers very many topics, but absolutely fascinating. Yeah. So essentially, those who were removed from the chains and were brought out of this cave in Plato's allegory into the world of light were expected to again return to the darkness of the cave to teach those left behind. So an obligation with the education. Education represented in the allegory by the chance to go into the cave, into the light, brought with it responsibility to share the knowledge gained from exposure to the reality behind the shadows. So by experiencing this, one has an obligation to share it. The reflection on this allegory raises some cautions that we would do well to consider, however, she notes. For example, the responsibility to return to the cave is a responsibility that carries serious costs. So it's not easy, it's not an easy process delving into history and reinventing all for the present. As Socrates and Glaucon agree in the dialogue, Plato's Republic is a dialogue written through the words and dialogues of Socrates, however it's written by Plato. Agree in the dialogue, Socrates and Glaucon agree in the dialogue, those who return to the cave at the very least risk being mocked by others, and in some circumstances run the risk of being killed for their efforts. So not only is there the obligation to share, but there's also the inherent risks through critique from society or even hate from society. The first months of 2017 suggest that pessimism is not displaced. For example, a lot of scholars have gained heat during the times of polarity. 10 states, for example, have passed laws allowing concealed carry weapons on campus, while several others have considered it. So there's also shifts in different direction, and that this direction is one I believe she does not agree. In June 2017, the National Rifle Association put out an ad called The Violence of Lies, which blamed the nameless they, who among other things used their schools to incite demonstrators and violent protests. Scholars have gone too far, they say, and encourage current events others have faced death threats and serious backlash, so there's a real sense of violence in this area. And that does not mean we should avoid trying to help our fellows. Rather, we need to spend some time thinking about academic freedom and working to shore up its protections. So there's just something to be said about academic freedom that perhaps the issue even existed during Plato's time, and probably well before. In Republic, Plato assumes that education functions as a complete break with the past. Thus, those exposed to the light are able to cast aside their old notions, so like a revelation, absorb new lessons completely, and take their fresh insights back into the cave where their new understanding to reinterpret the shadow of their fellow trapped below. It would be nice if this optimistic take on scholarly training were so, and it were guaranteed that we were free from the delusions of the rest of society. But, for example, in Racecraft, published by Karen and Barbara Fields, suggests that scholars are more likely than other members of society to be able to escape from the mental terrain and belief, what they call racecraft, that makes racism possible. At the very least, we need to beware of the possibility that our interpretations are influenced as much by the shadow of our society as by the light of day. So it's not inevitable that one will achieve this revelation. And in fact, it might even be more likely for scholars to be susceptible to past ingrained ideas. The final lesson from the allegory of the cave was one that Plato did not intend. Socrates' straight man Glaucon hints in the dialogue that when he objects that making those who got to the surface go back to the cave is a form of punishment, since it forces them to give up the opportunity of living in light for darkness, so there's obviously this negative notion. But when Socrates reminds Glaucon that this is necessary given the larger goal of achieving happiness for all, not just a few, Glaucon agrees under those circumstances. And for the purpose of Plato, this solves the problem, but it ignores Glaucon's objection. For example, why does society require working within the dark of the cave? We are not bound by Plato's overarching logic. We have alternatives. If we wish to help fellows left behind in the cave, we can. The most extreme try to bring the worlds of darkness and light together by destroying the cave. So why not explore it in light? Is it not possible to have a revelation in the light to begin with? If revolution seems too extreme for prudent scholarships, there is also the option of going back into the cave to explain what is keeping our fellows in chains. So why can they not come into the light is also an area worthy of research. The last option would require us to offer a different sort of knowledge, flipping the premise on presentism on its head, rather than starting with historical study and bringing it to bear to help explain the present. We need to start a careful study of the present, using our historical skills to interpret the world we find ourselves in today. Ultimately, Marc Blanc's study of the French defeat in the Second World War in L'étrange affaire demonstrates that the approach would require us to dig back into the past. But it would mean we would need to first unpack the world we find ourselves in, to call into question the darkness and the shadows in the cave, rather than accept them as given. So this is sort of quite an abstract way of really delving into the allegory, but what really defines what is the darkness and what is the lightness. Is it so binary? Can there be relative darkness within the light? Can there be dark or dark? And why is one stuck in the dark? Is it really a revelation if they're in the light? So all very important questions that are relevant to New Presentism. But overall, it is a very important field, as her argument is particularly important with the growing polarity in 2017. But I think my main takeaway is that just by keep iterating and by covering everything, hopefully the best and the most important will come to light. Not to make joke of the allegory, but she also notes that just having the virtue of the truth or virtue of some histories does not eliminate the lack of virtue of others. So that is the chapter by Elizabeth Dale. Moving to the slide, and then we'll move to the chapter of Paul D. Halliday and the comparison. So, institution, University of Florida, Department of History and the Lebanon College of Law. Positions, Professor of History, Professor of Law, as well as the coordinator for the JD, Master of Arts, and PhD programs. Suggested readings, Fight for Rights, A Legal History of the Chicago Race Riots of 1919, published by the University of Florida Liberty Press in 2022, The Robert Nixon Case and Police Torture in Chicago, 1871 to 1872, published by the Cornell University Press in 2016, Criminal Justice in the United States, 1789 to 1939, published by the Cambridge University Press, New Histories of American Law series in 2011. So that's just 3 of her books. She also has 3 more, so she's quite a prolific writer. In terms of the logos in the top left, we have the University of Florida, where she is currently a professor. In the top right, we have the Chicago College of Law, where she received a Juris Doctor. Below that, we have the DePaul University, where she graduated with her undergraduate degree in ancient Greek language, and Swarthmore College, where she transferred from. That is, ancient Greek is what she studied, which is a very fascinating topic for me, because I love everything Greek, as Richard Burton said in Cleopatra, but it is true. So that, and then to her research interests, to bridge the divide between the history of law and constitutional history by looking at when and how people have influenced systems of formal law. And as to the quotes, first quote, as I have noted in other contexts, I became a historian in order to use history to speak to and about the present, and that is what I have tried to do across my career. Next quote, for many years, the rule was simple, good historians rejected present-minded history. Next quote, historians of law have long voiced their own opposition to presentism, also known as law office history, or more recently, applied legal history, so some of the many names for this. As the summary suggests, political perspectives often drove the critics' concerns. So there's an underlying, some say it's liberal, some say it's conservative, but regardless, it's been a large aspect of the critique. Last quote, New Presentism's idea that historians have an obligation to use their training to help society has an illustrious pedigree. It is, after all, the point of Plato's allegory of the cave in Book 7 of the Republic, so it's an old truth. Her chapters in the section 2, Approaches Conceptualizing Legal History, chapter 17 of the book, the textbook, Spelunking, or Some Meditations on New Presentism. It's a very fascinating area. New Presentism, I think, is an area of history that a lot of people would find fascinating, and in fact, as she evidences, perhaps it might be an area where one might be most likely to find a career in this area. So, that is Elizabeth Dale. We will now move to Paul D. Halliday, and we'll learn a little bit more about her in comparison at the end. That's a little bit cut off at the top, but that's, you can still read it. So his chapter is in section 2, Approaches Conceptualizing Legal History, and his chapter is chapter 18, Legal History, Taking the Long View, by Paul D. Halliday. So a little bit about his life. He's the Julian Bishko Professor of History and a Professor of Law at the University of Virginia. He received his Bachelor of Arts at Wesleyan University in 1983, his Master of Arts at the University of Chicago in 1988, and his PhD at the University of Chicago in 1993. His fields and specialties are legal history, British, imperial, and global history from 1500 to 1850. He has 3 books. Recently, he's the co-editor with Eleanor Hubbard and Scott Sowerby in Revolutionizing Politics, Culture and Conflict in England from 1620 to 1660, published by the Manchester University Press in 2021. Habeas Corpus, From England to Empire, published by the Harvard University Press and the Belknap Press in 2010, the paper being published in 2012, which also this book received the Inner Temple Book Prize in 2011, and the New Statesman Favorite Read of 2010. So some awards for that book of his. Third book, Dismembering the Body Politic, Partisan Politics in England's Towns, 1650 to 1730, published by the Cambridge University Press in 1998, and the paperback coming out, published in 2003. Today, his main interest is to develop a history of the senses and law's material forms from the 16th to 20th century. More generally, he is interested in global history of English law from the 16th to 20th centuries, in particular the role of judges in constituting the empire from the Caribbean to Cape Town to Colombo. He is currently studying the Supreme Court of Ceylon in the early 19th century, and the adoption of the jury trials in criminal cases and repeated crises between justices and the island's British governor, especially during security crises. So much about the British Empire and history and law all tied together, very fascinating. And it's great at the University of Virginia, one of the oldest institutions in the United States. So his chapter is chapter 18, Legal History, Taking the Long View. So in terms of the introduction, some of these chapters do break them down into introductions, and not some don't, and unfortunately these two do, which make it easier to follow. So, introduction. There is no view without a viewer, which she said that is something he says, and Jane Austen understood this, he says. A pivotal moment, for example, in Persuasion, which is a book by Jane Austen, and it actually just came out on video as a movie as well, which I started watching. I actually haven't finished the movie, but and in terms of Jane Austen's books, I've read Pride and Prejudice. I love that, and yeah, great, fantastic author. But nonetheless, at a pivotal moment, readers in Persuasion join Austen's central character in their first sight of the sea at Lyme. So he sort of uses Jane Austen, as we'll see, as an example of taking a long view. He presents a passage from Persuasion in chapter 11, which evidences, I'm not going to read it out for you because that would take too long, but basically the passage uses 3 time scales. Enduring natural forces that prepared the ground for human life would be the first time scale. Yearly cycles of coming and going, another cycle, time scale, and the contingent events, such as the one that propel Austen's protagonists along the paths that none had foreseen. So there were different time scales that she's approaching, not just the linear. Only by putting the briefest instant in the longest possible view could Austen's characters make sense of it. So by applying the long view would imply encompassing all of these and therefore make sense of it. And furthermore, in this book, Austen demonstrates that the long view does not lie somewhere awaiting our gaze. It is a position we search out and decide to take, a position we might gain the kind of insights Austen provides at line. It is a position where multiple timescales converge to reveal the meaning of an instant of human action, and only when we take the long view can we make sense of the briefest moments. So kind of almost a paradox. By taking a long view can we understand the briefest moments, and this is something that he says Jane Austen manifested in her book Persuasion. So, next section, what is the difference between the longue durée versus the long view? So authors and writers in Austen's England thought a lot about perspective and the picturesque, what it means to choose one position instead of another, and what it means to frame and thereby take a view. Required a depth of field as much as involved breadth or attention to detail. Taking the long view, he says, requires foremost that we find a place where we might make the biblical observation, for example in Ecclesiastes 1:4, one generation passeth, another generation cometh, and the earth abideth forever. So, and as well as in Ecclesiastes 1:10, that's in the Bible, is there anything whereof it may be said, see, this is new? Yes, we can only see what's new when we take the long view. So, very old concepts, but it's not, when he says the long view, it differs from the longue durée. It's not just a long duration, but the long view in that, as we'll see, looking at different time scales. If length of time, he says, were the only requirement, it's already built into legal history. For example, especially in the Anglophone varieties, through precedents, for example, both in jurisprudential habit and in historical method, as is often involves in examining law's work across wide swath of time. So, by common law, for example, precedents, transactions, or just precedents, already includes this longue durée. But this is not the same as taking the long view. For thinking through precedents, it typically involves seeing the laws pass in the thinnest possible terms. So you're only looking at the one precedent and sifting through all the other unnecessary stuff. As so many pearls of wisdom tied together in the string of judgment statements. So it's kind of like a pearl, or like a pearl necklace he uses as an analogy for using precedents. Sir Edward Coke described law as birthright, deploying a spiritually charged language in which practices entailed future ones. So they're kind of connected, but it's like a thin line throughout history. Henry Maine depicted development stages in sedimentary terms. The movement of progressive societies has hitherto been a movement from status to contract, so a linear movement, status to contract. This is a dictum in which contract was taken as a proxy for liberal political order. This movement towards contract, towards liberal political order, Maine reduced therefore this three-dimensional geological metaphor to a line with a point at the end. So sedimentary would be three-dimensional, but basically by going status to contract, it's a linear history. Even though it might be a long duration, it wouldn't qualify for what Paul D. Halliday calls the long view. It's also this linear precedential view did not simply inform the future, it dictated the future. So by naming it this, you're only looking for things that satisfy the rule. Therefore, we take the long view when we search out a position from which we might discern a relationship among otherwise unrelated movements or phenomena scattered across multiple generations. So taking the long view would be looking at alternative things, looking where things connect where one might normally expect them to. We take the long view when we find the place where temporarily disparate objects unite in a single analytic field. So they might be temporarily disparate and not necessarily close together. A place where seemingly contrary things might be drawn together in a single analytic field. This generates what's called chronoesthesia, the ability to see present, past, and future in the instant. For example, going back to Jane Austen, her three dimensions of time, or as well Fernand Braudel, where he notes there's geographical time, social time, and individual time, where the first unfolds slowly and slowly and is slow to alter and tells the story of man's contact with the inanimate. The second refers to the gentle rhythms of groups and grouping. And the third and least is the frame which later historians like Coke and Main cast their macro gaze on the scale, not so much of a man in general as a man in particular. Brodel asked to accustom ourselves to a slower temper, sometimes almost borders to the motionless. This is the longue durée, using firstly taking a slower aspect of time, but also multi-dimensional aspects of time. That said, there is a difference between the longue durée and taking the long view once again. He says it is the difference between object and observer. Taking the long view, where one emphasizes our actions rather than things we act on. So looking at the actions rather than things we act on, or the object rather than the observer. And Brodel was sensitive to the perspective elements of the longue durée, but Halliday aims to build upon rather than critique Brodel. So Brodel was almost there, but Paul D. Halliday has a more revised perspective of the longue durée, or the long view, pardon me. So Brodel could, even though he had a multidimensional view of history and connected many dots and advocated for slower progression of time, he still qualifies for what Paul D. Halliday calls the longue durée. Value from the long view from two further propositions from Brodel. So Brodel still sort of hints at the two other aspects, though he might not hit it exactly as Paul D. Halliday would like. First, there are and should be normative commitments enlivened by our works. For example, there are problems we face now that only historical analysis can help us understand. So that is almost like the new presentism that Elizabeth Dale discussed. And then second, Brodel also evidences taking the long view requires a methodological pluralism. So the former also may flirt with presentism, as Sir Paul even uses the term, which is the previous chapter. A word historians, he notes, usually pronounce with a sneer, as Elizabeth Dale's chapter evidences. But presentism poses a problem only when we search the past invalidation of our normative commitments rather than for the others that lie out there. So that's only, he notes, kind of very much along the lines of Elizabeth Dale, that it only poses a problem when they're searching out for validation. And therefore the critique became reflexive. As R.G. Collingwood put it, the historians and jurists do so-called authorities is not to believe them, but to criticize them. So using it as a negative force. Also going to the second aspect of Brodel evidences, but not quite hitting on long view in his former observation of the three aspects of time, the plurality. And this may apply, is necessary in taking a long view, and this is Brodel's second proposition. We do not only get out our neatly prioritized gardens, but we leave our well-walled, disciplined gardens too. So moving outside the garden, that's a very old analogy too. And in part, he wrote an economics profession became ascendant in the public debate, so a plurality, so perhaps looking at other fields as well. Brodel emphasized analytic possibilities arising from confrontation among all disciplinary modes, from the social sciences through the humanities of law. So this is another aspect of the long view that is necessary, and requires disciplinary ecumenism. The principal aim, or aim of which I had to look up what this word means, because it actually, ecumenism means the principle or aim of promoting unity in the world's Christian churches. But I think he means this term more broadly in that uniting all the different fields, or uniting just to form a plurality. It is not some large or distant object we gaze upon, rather it is a position we take. So that's the difference between the longue durée and the long view. It's a position we take, not the distance we're looking. One where different kinds of convergence, temporal and disciplinary, might occur, so the plurality, but also different measurements of time. Looking out from that position allows us to hold disparate things together and see aspects of each kind of things we might never have seen considered that in their isolation. So that's the kind of the main goal of the long view, is to see connections where one might not have otherwise found them by just taking a long duration. But Brodel overall, I think, leads to a lot of conclusions that Paul D. Halliday seems necessary for the long view, and he's not critiquing Brodel, but rather just drawing much from it and building on it slightly. So where shall we take the long view? Where shall we find such places of convergence? It says, how shall we work there? Historical thinking distinguished from other modes of social cultural analysis by its engagement with specificity and by the attendant humility that counsels against overgeneralization. So there's this inherent issue with history in that it has to be very specific, and they also have to avoid overgeneralization. So which makes it difficult to take the long view. According to R.G. Collingwood, the things about which the historian reasons are not abstract but concrete, not universal but individuals, not indifferent to space and time, but having a where and when of their own. So even different geographies can drastically change the findings. History therefore cannot be made to square with theories according to which the object of knowledge is abstract and changeless. So Collingwood is saying there might be no absolute truths in history. And this is a problem in that the historian's obligation to specificity seems opposed to taking the long view's critical potential. So if it's too specific, how can we ever use the long view, and how can we find these connections where one might think they otherwise don't exist? But taking the long view threatens to involve us in this analytic hubris, and therefore this notion is more apparent than real, and gaining a synoptic comprehension generated from the long view requires humility in the face of always elusive evidence and careful attention to detail. So it's still possible. Just because two things might have different details doesn't mean they're not comparable. Going back to Austin reminds us reading the land and seascape means attending carefully to selected tidal pools, rocks, and structures, so specifics. To put another way, there is no opposition between microhistory and the long view. They require one another. Only in the long view do concrete things become legible as markers of continuity or rupture. So only by taking the long view do they become relevant. So in this way, Hayden White calls this choice prefiguring an essentially poetic act, by which the historian constitutes the field to be viewed. Lewis Mink called it comprehension, a kind of understanding which consists in thinking together in a single act, or an accumulative series of acts, the complicated relationship of parts which can be experienced only in seriatim. One way to achieve such comprehension, David Armitage suggests, is through serial contextualism, which yields a transtemporal history that sets synchronic engagements within diachronic traditions that are centuries, in fact millennia, old. As Mink put it, historical narrative does not demonstrate the necessity of events, but makes them intelligible by unfolding the story which connects their significance. So I think this is maybe an oversimplification in my mind, but I think of data versus anecdote. If you take many anecdotes, you have data. So even though this rock in Jane Austen's example might be green and this rock might be blue, which is very different, but if we have 10,000 rocks that are some kind of more green, some kind of more blue, then they start to become data and start to become more connected, and I think that would manifest the long view in that way. Collingwood imagined this in musical terms. The time beats of a symphony do not go ad infinitum before the music begins or after it ends, so a song has a start and an end, and even phrases have starts and ends. However, they form an organization which exists only from the symphony itself. So even though it might be specific to the symphony, it does not mean it's not part of a cohesive whole. And it is only once we have heard the entirety with all its parts that they reveal their meaning. Mink's analogy of a river uses analogy of a river, which first appears to blush as a linear image because of linear river, but it also is a form of evidence of chronoesthesia, which is the past, present, and future all at once, kind of like the old adage, one never steps in the same river twice. Benjamin convey the same need for a mental image that draws seemingly unrelated objects into what Mink called an individual act of seeing things together. In other words, image as dialectic and at standstill, so motion where it might otherwise appear to not be moving. Christopher Tolmans, one of the editors of the book, applies Benjamin's thinking to legal history in the critique, saying the critic or historian, Tolmans explains, constructs constellations, that is, new historical objects or dialectic images that join together that may be quite distinct phenomena whose significance can emerge only posthumously, or retrospectively in relationship with the now that has apprehended their significance. So I like that analogy a lot because it's a constellation, but if you actually, or within the constellation, it looks linear, but there's also that third dimension as well, but also it connects things where they might otherwise not be able to connect. Where if you look at a two-dimensional frame, you can see this constellation. When you move in a different direction, you might see a different one as well. So I think it's a really fascinating, relevant analogy. And in fact, probably my favorite in this, or the one that makes most sense to me. The bigger the constellation, the farther away we are from the other points surveyed as well, as you know. The better we are able to see our own presuppositions anew when they are made also into one of the objects in view. So by looking further back, that's where you will find more, and even further and further back. For example, some constellations are constituent parts of other constellations. More in considering constellations, rivers, or symphonies. Let's think further about the content about such an ethics by explaining the analytic surprises it can produce. So now that we've explained how we do it, he's going to share some of the surprises they produce. For it is the surprises that teach us most, and surprises that we will most readily see as the long view brings concrete things into combinations we can perceive by no other means. So now he gives us some examples in his second last section. And this section is called Writing the Long View. So a number of legal historians have for years written from the long view. Reviewing a few of their works demonstrates the possibilities, such as John Baker's The Reinvention of Magna Carta, 1216 to 1616, published in 2017, in that during the first 4 centuries provides an excellent place to begin, in that older narratives operated on the assumption of a persistent appreciation of the Charter's greatness and moment it was produced. However, this assumption came from the sustained traditional liberal narratives about the origin of rights of the Anglophone world and their connection of legal practices. Baker, however, in his work tells a very different story by searching in a constellation of places, such as at inns, of courts, in surviving manuscripts of judges and barristers, and in debates about personal liberty and the privileges of church. And it's surprising to find that there's much silence actually on the topic of the Magna Carta for much of the history. Little but empty space, occasionally broken by narrow invocations of the Charter in the 14th and 16th century. This changed in 1581 when Robert Snagg gave a public lecture on Chapter 29. Citations to the chapter increased in number and the importance therefore, and out of silence, Chapter 29 suddenly became the linchpin of the Englishman's peculiar liberty. Baker follows this discourse liking liberty to the Charter for the 35 years after Snagg's lecture, as Sir Edward Coke promoted views that would be carried forward in legal political debate, and centuries followed, so Edward Coke later picked it up as well. But Baker reveals the highly contingent ways in which the Charter that languished in obscurities moved with surprising speed to the center of the English legal imagination. So by taking the long view here, if you're just looking at the longue durée, you might track all the uses of the Magna Carta over history, and one might not actually see the scale in which it grew in popularity, and that in Baker's work we see that for much of the time by looking at the absence rather than the presence of the use of the Magna Carta, and we find that it was actually very quiet and wasn't actually that popular at the time. And also there's this notion that that Anglophones are proud of it, so they try to justify it being popular throughout all its history. But for much of its early history, it was not even used that much until it was later picked up by Robert Snagg and Sir Edward Coke. A different book that yields equally surprising observations, according to Paul D. Halliday, from the long view. While Baker concentrates on Mandarin legal sources, Amy Louise Erickson studies sources of everyday life in her book Woman and Property in Early Modern England, published in 1993. There's a sweeping account of woman and property from the 16th and 18th century, and finds most men actually wanted women in their lives to have independent command of property, despite the profoundly patriarchal world. By working in the archives of church, courts, and equity, and spends more time on non-litigation sources, testimony records, bonds for separate estates, and by doing so reaches the astonishing conclusion that coverture was socially at least a fiction. Nevertheless, changes over time occurred. For instance, in the 17th century, statutes deprived women of advantages they once enjoyed in ecclesiastical law, so there were also recessions as well, or in terms of the development of women's rights. But by taking the long view, Erickson establishes quite a different account of the long-standing experience against which development, like statutory changes of law, appropriates take on a surprising appearance. So two things here. Firstly, there was some retrogressive motion to it. It wasn't just linear, but also, it was actually, perhaps, if you just look at it in a self-fulfilling way, you might see, oh, the women's rights were not very strong at this time, but there was actually, maybe outside of the law, there was actually some appreciation for women's rights by looking at alternative sources, and particularly by using this use of the long view. The next example he uses is John Collins' Martial Law and English Laws, circa 1500 to circa 1700, published in 2016, shows how we can only appreciate the meaning of short-term developments by taking the long view. Contrary to centuries of dicta that insisted that martial law operated outside the law, finds that it was understood, debated, and practiced as one of the many laws of England. So martial law was actually part of the main body of laws of England. By exploring the late medieval period in the 18th century from England to Ireland and the Caribbean to Africa and Asia, shows martial law was dynamic but not arbitrary and deeply inflected with civil norms. Andrew Fitzmaurice, in his book Sovereignty, Property, and Empire, pardon me, from 1500 to 2000, published in 2000, shows the same in his half-millennium account of ideas and practices concerning the occupation and sovereignty as a site of debate about the legitimacy of European empires. Namely, by taking the long view, it allows Fitzmaurice to redate the onset of the liberal terra nullius, which he finds was applied to colonial lands much later than we have supposed. So, just by taking a long view, we can see that the term terra naval was applied to colonial lands later than it was supposed. So even though most scholars would try to, especially if you have an agenda to make colonialism seem bad, you might say that these things started earlier, but they actually did not start until later. Next example, Lauren Benton's Search for Sovereignty, Law and Geography in European Empires, 1400 to 1900, published in 2010, puts geography at the heart of her 5-century long analysis of European law's global walkabout. Standing at the temporal topographical junction, she charts law across multiple geographies, rivers, lands, and oceans, and mountains, to show that Westphalian sovereignty was actually an illusion, and is seen from the long view. Divided sovereignty appears less as a temporary concession to a particular challenge of administering empires, and more as a central premise of rule. So basically, she looks across all the regions, many geographical regions, and sees that perhaps there wasn't anything distinct about Westphalian sovereignty, but rather it was a response to the geography, as many have argued that, or I've seen argued that Europe could not be united because of its difficult geographies. It has lots of mountains and very different peoples, but for example, why might one note why there's so many different languages in Europe? It's because there's a lot of actual geographical barriers. Lastly, the last example, Christopher Tomlins, one of the editors of the book, of the Oxford Handbook of Legal History, in his freedom-bound, Law, Labor, and Civic Identity in Colonizing English America from 1580 to 1865, published in 2010. By carrying the American experience at the intersection of law and labor back to the Elizabethan servant law, reveals how for centuries freedom and unfreedom have come together. The revolution that formed a new nation means much less in light of the persistence of the fact that freedom and unfreedom have always been conditions for each other's existence in American life. Again, taking the long view here shows that its chief benefit is in the generation of surprises. In this case, surprises disturb the most traditional pretenses of sovereign isolation that still bunker so much legal historiography. All authors that take the long view, a place where they could put apparently unrelated objects into the otherwise unseen constellation, thereby revealing the ways in which such objects were and are related. So essentially here, Christopher Tolmans uses the long view, and Christopher Tolmans uses as an expert in almost all aspects of history of law, uses the long view to find unique findings about the relationship between the freedom and unfreedom in the United States. But not just by looking at a long span of time, because it's less than 300 years he's looking at, but a different way of applying the longue durée, which is the long view. So moving to the last section, the long view's future. So where do we go from here? Where do we go now? It's a Guns N' Roses reference. All the books discussed are monographs by single authors who worked in isolation in a manner of long practiced by historians. So a lot of these people worked in isolation and their works are independent. However, they also seem to converge in that they all took the long view. And there's no reason why individuals cannot continue to produce long view histories of particular phenomena individually. For example, histories of law concerned with water and with the expropriation of property for the public good, which is a book he references by Joshua Getzler, who is also one of the authors in the Oxford Handbook of Legal History that I previously covered. Absolutely fascinating section where he tracks the history of Roman law throughout civil law jurisdictions and also the history of common law, one of my favorite chapters. But in his book, A History of Water Rights as Common Law, published in 2004, but also by working across multiple generations, raises problems of scale, of the length of the flows we must chart to identify the critical objects that require explaining. So as we expand the scale of time, there's also generational factors we must look at, and of the number of such objects from across the centuries, and thus the volume of sources we consult. So it can often be overwhelming if you take this long view. How many dimensions and how many data points do we look at, and lack of data points do we look at? So he says the long view's future may look different from the past. Specifically, digitization gives us new solutions to these problems of scale. Digital archives put more objects in our view. One possibility lies in making a single massive text object out of many text objects of the same kind. For example, the Old Bailey proceedings have gathered all reports of the cases of the Old Bailey. When I think of the Old Bailey, I think of Tale of Two Cities, but it's a famous court that heard most felony cases in London and Middlesex from 1674 to 1913. There's over 127 million words covering 200,000 trials, and the words are searchable, and it becomes possible to answer a number of questions about the transformation of particular aspects of crime, criminality, and criminal law, and to think about the relation of such transformations to other cultural, social, and political developments. So these valuable technical resources are opening up new areas in using the long view. Of course, no one has read all of the Old Bailey session papers, so this is impossible on the individual level, nor ever will. Fewer still will read all the English reports of statutes of the realm, but this depends on what we mean by read. For example, Franco Moretti has shown through his analysis of literary texts how computer-conducted distant reading yields insights no amount of close reading can. So just scans, quick technical scans, you can learn a lot more even if it's impossible to read all the content. In his Graphs, Maps, Trees, Abstract Models for Literary History, published in 2007. He also quotes Brodel approvingly. History is indeed a poor little conjectural science when it selects individuals as its objects, but much more rational in its procedures and results when it examines groups and repetitions, topic modeling, and changes in as well in titles of books. So just by scanning titles of books, you can see topic modeling is how topics of books change over time. All texts currently are susceptible, however, but to machine reading share one characteristic. They were all appeared in print. So what about things that did not appear in print? So it's kind of self-fulfilling in some sense, and they also all had that similar thing. For example, there are obscure some of the richest part of our archives and abstract our perspectives on questions we cannot see. There's alternative sources such as image of manuscripts present opportunities. So manuscripts are handwritten. For example, the Anglo-American legal tradition, AALT, it uses the U.S. Postal Service to sort mailing using machines capable of recognizing human writing. So this could be used to gather manuscripts and put them into digital form. Most ambitiously, the German project Transcribus is applying machine learning to develop intelligent handwriting analysis, first transcribing some text, then linking the transcription to an image of the manuscript of the text. Of the text, the machine can learn and read a particular hand. So this machine can be trained to read a particular hand by, like, you use a reference, just by some reference words. Still, there are significant varieties of clerk writing, so some might just be impossible to read or just too difficult to read for it, and there's too many to make this feasible. But we must look carefully on each start to understand a constellation, so it's still worthy of pursuit, and we can still find constellations. Law and its sources manifest chronoesthesia, imaging past, present, and the possibilities of future all at once. As we realize this, we begin to see these norms as a result of choices made in surprising moments rather than as inevitable consequences and processes no individual might have shaped. So start to see more of the meaning behind it. And one problem with the longue durée, as Brodel understood it, is that we see objects as non-moving. However, the long view addresses this by allowing us to see forces that appear motionless, weren't, and aren't. And as we do this, we appreciate how our law has been and remains a result of conscious effort to articulate the good and to fashion practices for obtaining it. And therefore, we watch the normative commitments of others, some repellent to us, others surprisingly attractive upon close analysis. So they're looking at all data forms, data types, times of frame, and as they reveal themselves in the past. And therefore, we may see past commitments might do as we ponder what they mean, those we mean to live by in the future. So that's the past, present, and future aspect. So that is also a presentism aspect where hopefully has an implication for the present, but once again not self-fulfilling, as Elizabeth Dale would agree. So moving to the slide, and then we'll go to the comparison. So the institution, University of Virginia, the Coron Department of History and School of Law, University of Virginia. His positions: Julian Bishko, Professor of History and Professor of Law. As well, suggested readings: he's the co-editor with Eleanor Hubbard and Scott Sowerby, The Revolutionizing Politics, Culture and Conflict in England, 1620 to 1660, published by the Manchester University Press in 2021. Habeas Corpus, From England to Empire, Harvard University Press and Belknap Press, published in 2010. Dismembering the Body Politic, Partisan Politics in England's Towns, 1615 to 1730, published by the Cambridge University Press in 1998. The logos in the top left, we have the University of Virginia. Top right, we have the University of Chicago, where he received his PhD. And below that, we have the Wesleyan University, where he received his Bachelor of Arts. Pardon me. His research interests: legal history, British imperial and global history, 1500 to 1850. His research interest is to develop a history of the census of laws, material forms from the 16th century, the role of judges in constituting the empire from the Caribbean to Cape Town and Colombo. His quotes here: "There is no view without a viewer. Jane Austen understood this." Next quote: "Taking the long view requires foremost that we find the place where we might mind the biblical observation that one generation passeth away and another generation cometh, but the earth abideth forever." Ecclesiastes 1:14. So that kind of contrasts the issue with different generations. There is sort of connection, right? People say there's different generations change so much, but there's so much overlap. There is the baby boom. There are bubbles of generations, but there's also so much overlap. And this is just an analogy, however, that applies to all of the long view. Taking the long view of laws past involves more than a broad survey. If length of time considered were the only requirement, then taking the long view would seem built into the legal history, especially in its Anglophone variety, so using precedents is built into it, but that is not necessarily the long view. Last quote, the length of the view thus derives from the way it depends on and generates chronoesthesia, the ability to see past, present, and future in an instant. So that is also, the future is also a very important aspect too, in that there's an aspect of new presentism as well. So that his chapter is in part 2, Approaches, Conceptualizing Legal History. Chapter 18 of the textbook, Legal History, Taking the Long View by Paul D. Halliday. So, moving to the comparison in the style of Plutarch's Lives, that is, in my opinion, the best way to learn about individuals is through the comparison. It's not that these individuals are ever contested against each other, or even, I actually, as we'll see, I think they might perhaps know each other, but nonetheless they were put together because they are next to each other in the textbook, but also they're in the same section, which leads relevant comparisons. So they're both professors of both law and history, so that is, I think, unique to these two. There are some other individuals in this textbook who are both professors of law and history, but some are just professors of history, some are just professors of law, but these two both happen to be both, so both are dual professors. However, Paul D. Halliday is not actually a lawyer. He does not actually have a Juris Doctor, whereas Elizabeth Dale did receive a Juris Doctorate degree from Chicago, Kent. They both did get a PhD from the same university as well, however, the University of Chicago. One, Elizabeth Dale graduating in 1995, and Paul D. Halliday graduating in 1993, so it's likely that they knew each other at this institution. They, in terms of Elizabeth Dale, her undergrad was in ancient Greek, and she also transferred from Swarthmore College to DePauw, so she's also a transfer student, which isn't nothing good or bad about it, but it's something to note about their academic movement. However, Paul D. Halliday did not transfer, but they both did start at a liberal arts college, with Elizabeth Dale starting at Swarthmore College and Paul D. Halliday starting at Wesleyan University. I can't necessarily find what Paul D. Halliday studied for his undergrad, but I believe it was history, and that does differ from ancient Greek by Elizabeth Dale, which is quite a little bit more unique. It's not as popular of an area of study as history more generally. And then in terms of books, Elizabeth Dale has produced 6 books, whereas Paul D. Halliday has produced 3. But the number of books does not necessarily mean one is better than the others, but one just can conclude that based on them graduating their PhD at a similar time, the amount of work they produced in terms of books is quite different. It's by a magnitude of 2. And then lastly, their interests are slightly different, particularly in respect to this chapter. Elizabeth Dale is concerned with new presentism, whereas Paul D. Halliday is concerned with the long view. However, there is some overlap in that I think new presentism is relevant in the long view, and I think the long view would be helpful in applying new presentism. So that is the comparison of Elizabeth Dale and Paul D. Halliday and their 2 respective chapters, those being, for Elizabeth Dale, Spelunking, or Some Meditations on the New Presentism, and for Paul D. Halliday, Legal History, Taking the Long View. So, thank you so much for watching this video. I hope you supported. These are 2 chapters from the Oxford Handbook of History, and I hope you continue to support them. Thank you so much.